Good afternoon. And Amini, thank you very much inviting to address this young gathering here. And I really appreciate your main objective to give the direction to the entire nation to the correct direction. This is the most important thing as citizens of this country. What is as a role of citizen, what is our duty? You and I all are members of this society. As a member of this society, not only this movement, not only Namini and his team, so we all have that responsibility. Anyway, that we must thank this movement to initiate and to get this leadership to bring this entire nation. That is a very good intention. That must be the intention of any citizen of any country, to bring the nation to right direction. In this journey, in this mission, we must know the environment first. Environment in the sense, now here, we are in this society. We are one member of the society. When you are living in this society, we must know the basic laws of the society. Ignorance of law is not an excuse. That is the basic thing. This may be the basic thing. Even how do we know these laws? There must be a place to learn. So at the moment, we can't see a place to know the law. Only the websites are there. Then, of course, we have to go through each and every law of the country. Then only that we can say, yes, we know the basic law of the country. Is it possible? This is another question mark. If something happened and when we go before courts, only the court system, judicial system says, ignorance of the law is not an excuse. So this type of workshop only that we can introduce, and we can gain knowledge, upgrade your knowledge to a certain level. That is what they are envisioned. So voluntarily we also came forward, understanding or realizing your objectives of this movement. Now today's topic is right to information and data protection. Right to information and data protection. There are two aspects. So before I go to the next slide, first slide, I must come to an agreement with you. Under law of contracts, we call this as the agreement, legal valid contract. What is that agreement? Even you like or not, because under contracts normally that we get the conditions and terms on both parties. Here I am going to give you terms, whether you like it or not, you have to accept. What are these terms of contract? You have to ask more and more questions, please. Please ask more and more questions at the end of each module. Otherwise, I don't know whether I am delivering that you are absorbing properly. So otherwise, at the end of the day, I will address you. Okay, all right. Then ultimately nothing would happen. So when you ask questions only that we can come to the same frequency, then I know what the level of your knowledge in this area, what are the information you need to find out. I hope that you agree. Am I correct? Right, okay. Next slide, please. Let's see what is privacy. What is privacy? What is privacy? Before all right, slide is there. Now, privacy applies on data. That might be different for different people, since privacy doesn't carry the same meaning of confidentiality. I hope that when you work in any organization, there are some confidential secretaries. What is the role of confidential secretaries? To safeguard, protect. Sometimes the organizations, they have their secret data. They have some secrecy. It's a duty of that secretary or the staff to secure their confidential information and to work. That's the role of confidential secretaries and confidential secretary staff. But it is not privacy. Privacy is something different. Now, when you take privacy, up to date, we couldn't give proper definition for privacy. Now, let's see that what Samuel Warren and Louis Brandeis in their book, what they said. It's valid even today. considering the time period, considering the geographical location, the privacy can be different. Privacy is also developing, privacy is also changing. Now take example. The way you wear, especially it's applied for young ladies. Now, there is a way to wear in France or Germany or those countries. Can you wear in the same way when you go to Middle East? You can't. Then take eras. We don't know whether right or wrong because we have not seen these frescoes, the secret frescoes. So we have seen from big pictures. That's how they were. Today you can't wear like that because we have lost that privacy. Now we can say, I want to give you two examples. With the time difference, the privacy can be changed. Even when you look at the geographical location also, privacy can be changed. Privacy is not the simple thing. We can't give exact, correct or definite version for privacy. Under these circumstances, we have to learn this subject. Next slide. Why these privacy policies or data privacy, whatever the name given, we are going to discuss the same subject. Jurisdiction to jurisdiction, data protection laws are different. Privacy policies or privacy laws are different. What's the reason for that? Any parliament, any legislature, they make laws to a particular country considering socio-economic, political and cultural reason. When you look at laws in this country, sometimes there we can see some differences. When you look at the laws available in Singapore, laws available in Japan, laws available in Canada, because those countries have introduced their laws according to their socio-economic, political and cultural reasons. Now we also have introduced laws following the same. Now take example, we have 4 personal laws in this country: general law, Canadian law, Muslim law, Desavalama law. Now you can't find, even today that it's difficult to find Desavalama law even in India. And Canadian law you can't find in any other country in the world. Muslim law, of course, there are some, because it's based on the religion, and general law. Now we introduced these 4 laws at the time of getting this independence of the country. That's a requirement following Colebrook Commission and Salisbury Commission. And this is how they force us to introduce these laws. Now we maintain these 4 laws because that is the requirement of the society, requirement of the country. That's why you can't find the Canadian law in Maldives or India. So likewise, we have to apply the same theory here. This is the reason why the jurisdiction to jurisdiction, application of data protection, application of right to information are also different. Basic principles are same, but we can see some deviations. So these are the main reasons we can identify for this aspect. First is due to political reason. Now take example, in 2005, as a political reason, we introduced a Right to Information Act. Right to Information Act. This is what briefly we are going to discuss here today. Other countries, when they introduce Right to Information Act, in the meantime they introduce Data Protection Act as well, because the reason is without having data protection law, you can't maintain Right to Information Act properly. Even if a country has only Data Protection Act, without having right to information, still you can't maintain Data Protection Act. Data protection and that right to information are 2 sides of same coin. So the political reasons, of course, in Sri Lanka we introduced Right to Information Act first, without introducing Data Protection law. Now this is the 8th year we are, because this came into operation of this act. Now we are discussing this act after 8 years. When you look at judgments delivered by courts, it's very few. Very few. The one reason is there was no data protection law. Anyway, after considering, I will come to that later. After considering various issues, there was no other option. Sri Lanka also had to introduce data protection law last year, Act number 9 of 2022. Then another reason is economic strength. Now take China. China also recently they introduced data protection law. Earlier, they didn't want to have intellectual property law or data protection law. Now, it was the trend. When you wanted to buy some cheap items, we went to Chinatown in any country. Why this goods so very cheap? Lots of fake items there. Because China didn't believe intellectual property law earlier. But they realized, they knew if they continue like that, they will lose the international market. So then what they did was they honored intellectual property rights of people. They introduced intellectual property law. So likewise, they introduced data protection law as well recently. But when you look at their data protection law, they maintain basic principles. But when you look at interpretation given for various words, this is not the same interpretation given like in Western countries. Same words are there, they are given different interpretation. The reason is China give priority for state security. State security. For when you say data protection, they want to protect their data for the security of their country. Under this situation only, they have introduced their data protection law. On the other hand, when you take European Union countries, we can see they are trying to maintain the uniformity of data protection law. Then what is the situation in countries like United States? The United States, there is no particular law relevant to data protection, except in California state. California, of course, they have a statute following European law. Other states, they don't have law. But they have various statutes. When you are trying to find out what are the provisions come under American law, as far as data protection is concerned, we have to follow various acts. Anyway, American export market is in European Union. If they don't follow data protection laws available in European Union, they can't export their goods to United States. So therefore, they voluntarily they came forward, then they accept laws relevant to data protection in United States, in European Union countries, even in right to information. Because there's a economic strength is there in EU countries. Same thing happened to Australia. The dairy products go to European Union. So they have to honor the same. But what happened to Sri Lanka? Our tea market is there. What happened to our tea market? Are we the leading people in the world? Tea export? No. What happened to our tea market? Who are the leading people at the moment? Yes, Kenya. Kenya captured our market. There are some reasons. I will come when I come to data protection. Then another reason is a continuation of traditional agriculture. This is also a reason why some jurisdictions maintain different type of data protection. Take example Mongolia. Mongolia still they carried traditional agriculture. So they don't need to have very advanced data protection law to that country. So still they don't have data protection law. Then development of industries and technology. Especially take examples. Development of ICT industry. Now the data protection is a must. Right to information is a must. Then involvement of international trade. So this is what happened in Sri Lanka. After realizing very soon we will lose the market, especially government, industry and the market. We can't send this item to European country. We will lose tea market day by day. So then that means we will lose international trade. After realizing, at least last year we introduced Data Protection Act. Then involvement in international politics of the countries. This is another reason. This is the country, they are under geopolitics. Right? We are getting pressure from all four corners. Luckily, southern, of course, there is no countries, only Maldives there. Otherwise, three corners we get pressure. If they ask us to introduce law, yes, we will just introduce that law. There are some laws. We have hired these laws from various other countries. We don't know whether we can apply these provisions in this country. Next slide. So these are the reasons why the jurisdiction to jurisdiction, we can find different level of data protection law and Right to Information Act. Now, when you take, it is privacy or data protection, it is not easy to give a guarantee of equal protection on privacy or data that can be uniform universally. This is the reason, because country to country, laws are different. Anyway, we can identify at least basic and minimum privacy protection that is relevant to any civilized society. Now, I will ask one question. Please tell me, what are the places we can't fix CCTV cameras? Just tell me. What are the places? Not we can, I am asking we can't. Washroom, okay. What are the other places? Private properties. So from where did you find this? All right. If someone fixed, what are you going to do? Take a pole and hammer. Okay, this is first step, all right? Legally. Now, I'm asking this prior to 22 Act number 9, right? Then now we have data protection, okay? Now we can give long list, washroom, dining room, like we can say. But where was the law? If there is no law, you can fix CCTV cameras anywhere. I don't know whether that you got that incident 7 years back, soon after introducing Right to Information Act at the textile shop closer to Dehivala, Vellavath. There's a textile shop, especially ladies' garments are there. Inside the change room, the owner had fixed a CCTV camera. One lady, when she went there, she had seen CCTV camera was inside. Then she had complained. Then police came and asked from the manager of that place, why did you fix this CCTV camera there? Those days, all started to talking about this Right to Information Act. Then he came with fine answer. What was the answer he gave? I heard this right to information is there. I want to find out. I have right to know what is happening inside my premises. It's a fine answer came. But anyway, that I think that lady also didn't want to go ahead with that matter. This is the situation most of the time. Our people, they don't like to go to police station and courthouses. We, of course, we have to go there. There is no other option. But anyway, normal person, they don't like. This is the truth. To go to police station and courthouses, then they feel that not spend time, they feel that just waste their time, wasting of their time. So maybe due to that reason, they didn't go with it. Anyway, you see that answer he gave, right? So we can't find fault with that person. Also. All these newspapers carried the right to information. So this is what he gathered. Now, I hope that some of you all have that experience, especially I can see some UK solicitors also in this audience. That we can, when you walk on street, they have put up board saying that CCTV camera is in operation 50 meters ahead or 100 meters ahead. But here, of course, are hidden cameras. When police also fix camera, they have hidden places. You can't do it. If they fix CCTV cameras, you must give that notice. Why? What is the message they give? This was part of our subject today. If the young couple walk very closely, after seeing that, of course, they keep the distance and walk. Otherwise, that trip goes to their parents, of course, there can be some other problem. To avoid that, now here, of course, CCTV cameras are there. I haven't seen any board. No notices given. Next slide. Now, when you say data, this word came after the development of computers and network. Earlier also that information is there. We had privacy. But we call this data for information because of these computers and network. Anyway, without using Without living with computers or network, we can't survive today. Now that is how this word came, so data. Now there are two types of data. Our protection is there only for private data. That means we call this data as sensitive data. We can't protect all data. Now take example, if I want to find out about you, if I type your name, if you have written any article, if you are a member of any movement, association, your name is there on website. If I want to know about Namini, I can type, yes, there are I think more than 7 to 8 websites carry your name. Your name is there. So these are not sensitive data. These are not private data. We call this data as public data. We can't apply data protection for public data because it is in public domain. You will get protection for sensitive or very private data. Sensitive means very private. If I ask you, what is your eating habit or drinking habit? For a joke, you will say various things, but you don't like to tell me exact drinking habit or eating habit. This is a sensitive data. If I ask the question from the Japanese or the Chinese person, what's your religion? They don't answer. Don't ask that question even. Don't ask. They say, I have no religion. Now, this is a new trend in European Union countries. Even at the job interviews, you can't ask, who is your father? What they say is, mother is there, child is there, that's enough. If they want to recruit that person for intelligence service and armed forces only, they ask their pedigree. Otherwise, they can't. Our birth certificate, not only father, even our great-grandfather's name is also there. So that means, relevant to your movement, you have liberalized the situation now. It's called liberalization. So there are lots of marriages that are not the marriages, the legal marriages are not there. Anyway, that child must have the right. Citizen must have the right. There cannot be discrimination because of the marriage certificate of parents. This is the situation in EU country. So that is why the time to time it's changing. Any civilized person on the earth feels that he or she must have certain individualism and reluctantly expose some information about him to the rest of the world. So this is the reason to introduce these laws. Next. Now, in opposite, if you are living in any democratic society, democratic country, it is our right to know certain information. That is nature of any democratic country. Now, take example, community disease spreading in a particular area, especially that happened during COVID period. Now, COVID pandemic, during that period, of course, it's a virus attack to a person. That person might feel that this is my privacy. Why should I tell others? Anyway, as a democratic society, we must protect, safeguard the society first. For that reason, he can't expect this blanket cover for that. On the other hand, take HIV. HIV person has that right. Because there is no spreading unless there is not airborne disease. If any person wants to go not closer to have sexual contact with that person, he won't get it. But COVID is a different. It's airborne disease. Now, COVID is also virus, HIV is also virus. But this is how this privacy came into operation. In the one instance, there was no privacy. There is no protection there. On the other incident is there's a privacy. Because first we have to consider safety of the society. Right. So as a result, now you can see this. It's a big battle now between data protection or privacy policies versus right to information. Any democratic country, the role of any democratic country is to balance these two. So otherwise, we can't see the particular country is a very successful country. So on the one hand, we have privacy policies. On the other hand, we have data protection. So it is the responsibility of the responsible government to balance this situation. Next. Now first come to Right to Information Act. Briefly I will explain you this Right to Information Act considering the time factor. Anyway, you can download this act that is there. Go to Google search. Only at the moment we can discuss only these provisions because there are no much decided cases from Supreme Court or Court of Appeal to analyze these provisions. Anyway, when you look at some judgments in EU countries, some judgments in India, that you will come to know what is the exact right to information because we also hired these provisions from these countries. So based on that, we can get some idea. When you look at this act, especially the preamble is the most important. Why the government, why this parliament, legislature introduced this act? This is an act to provide right to information. So that means the provisions are there for right to information under this act. To specify grounds on which access may be denied. There are certain grounds. The next slide I will give the long list of subject matters. There are some subject matters you can't expect this right to information. You can't get this information as a right under this act. Then to establish right to information commission. There are sometimes when we ask to give some information from public authorities, remember when you look at Right to Information Act, you can apply this for public institution only, ministries, department, corporations, or other projects or whatever it is, public institutions. You can't apply this for private institutions. In Australia, time to time they declare the annual income. If the particular organization exceeds that amount, then people have right to get information about the organization. But in Sri Lanka, that provision is not there. Remember, you can't apply this act for private institution, only for public institution. So there are some limitations we can see. And after making an application to give some information from this government institution, for some reason, if they refuse, then you can make an application to this right to information, the commission. That is why this commission is set up. That is your right. That is your right. Even the commission give wrong decision, then you can go to Court of Appeal. So this is how we maintain this act. Then it is the duty of various institutions to nominate special officer, right to information officer. That is his duty to follow this law and instruct properly and to decide whether that applicant has right under Right to Information Act or not to decide. If he says that, if he feels that it comes under exceptions to the subjects declared as exempted subjects under this act, then he will decide not to give that information. But if the satisfied party can go to this commission and next to the court as well. So this is what the final objective is there, appointing of right to information officers. Next slide. Now these are this is the only, I highlighted some items only. There's a long list, they are accepted. Now take some example. Causing serious harm to the defense of the state, its territorial integrity or national security. If that information relevant to that, the right to information officer decide that it comes under this category, then he will refuse to give this information. Likely to be seriously prejudicial to Sri Lanka's relations with any state or international organizations. So once again, the ministry will not give that information to the applicant. That exchange rates or the control of overseas exchange transactions, regulation of banking or credit. Also, you can't get information. Most dangerous part is taxation. Taxation also you can't give the information. On what basis you started to impose this percentage? Now, this is why most of the now professionals have started to leave the country due to the tax system. Then you can't ask, why did you inform? Why did you impose this percentage? This is not your right, because they have excluded. So likewise, take another example. Entering into overseas trade agreements, another dangerous area. So you can't ask. Why do you come to the ECTA agreement or like the bilateral agreement? The ministry won't give reason for that. Then the medical records relating to any person. That's also fair enough, because you can't ask this medical record to another person. And confidential information supplied to a public authority by a third party. This is also fair, because otherwise there will be no decoy, there are no informants. If they disclose so-and-so is the person who gave this information to police, then there won't be any police informants in the country. So like you can see, there's a long list. That's why at the time of introducing this sector, there was a big issue. The media protested against this act, saying that earlier somehow they got information. They had various channels, contacts, they got information and they published. But after introducing this act, of course, that act is there to right to information. The preamble and name is very nice, right to information. But ultimately we have lost that right, because they have excluded various items. Anyway, as a citizen, these are the most important matters to know. As a citizen, I must be in a position to find out what is our fiscal policy, financial policy of the country and foreign policy of the country. Otherwise, how to live in this country? It is my right. But look at this list. Of course, if I ask this information, sometimes I don't know. This right to information officer can say, I'm sorry, I can't give the information because it comes under this one of these items. If it is so, we can't. Next. Right. So this is about right to information. Now come to data protection. Now ICT, Information and Communication Technology, is developing, and privacy issues of personal data of the internet users also equally increasing. That's what we have experienced. I'll take example, using and misusing of private and personal data in social media, especially in Facebook. Especially on Facebook. Now, Nielsen study reveals Singaporeans are highest frequency of internet access, the people in the region, with 80% of Singaporeans accessing the net daily. This is the situation. The latest ranking from Alexa shows that Facebook is among the top 3 sites in Singapore in terms of internet traffic, along with Google. There is no proper survey carried in Sri Lanka at the moment, but we can just get some idea. Our country also now second to Singapore. Next. So this we can see the development of technology has no territorial boundaries. So this is the threat now. This is the challenge before us. So as a member of legal profession, this is the serious challenge before us. And the judiciary also, when you look at judiciary, also they also have faced this issue. Because we can't keep data, considering the nature and behavior of data, electronic information, within the limits of particular jurisdiction. Every time it crosses borders. Now take an example. If I want to send email from Colombo to Jaffna, email I am asking, what is the path? What is the path of this email? It's going via like a train to Polgahawila and Kurunegala and Radhapur and Jaffna. No. The message will be divided into various message packets, considering the traffic data. Sometimes, we don't know, considering the situation, sometimes these message packets will go to Cape Town and come back. Or sometimes it go to Pakistan or somewhere and come back. Because there is a way to balance traffic, peak hours and non-peak, according to peak hours, not like traffic diversion by police cops. The same mechanism. So, if it is so, of course, now, when this data travel over various jurisdictions, this data will be subject to the legal system of that country. Sometimes they can detain. Sometimes they can detain. We don't know. If the towers in Saudi, in some Middle East country, realize that some prohibited items are going as attachment with this email, if they want, they can keep. But it is not illegal, say in Germany or France sometime. What is illegal there? So anyway, considering the nature and behavior of internet, especially in the cyberspace, so we have to take some special steps, specific steps. If I ask you a question, where is cyberspace? What is the answer I get from you? Where is cyberspace? Where is that? All are talking about cyberspace, where is that? Earlier, of course, even under international treaties, we have a number of treaties relevant to air, sea, and road. International treaties also there. But the jurisdictions, they are up to orbit. Now, we send electronic message to Pluto, sometimes outside the Milky Way. Where is the ending point? We don't know. Now we have expanded the jurisdiction. What is the ending point? Last point of jurisdiction, up to the point you send electronic message. Earlier we didn't have this issue. So this is a serious issue now. When we communicate through this electronic medium, these are the practical issues. When we send messages, all this right to information matters and data protection, everything is also involved in that. When you take cyberspace, of course, there is no territorial jurisdiction. It's a global village. But unfortunately, countries have not realized, or now they have not stepped into that. Of course, countries have their territorial jurisdictions. They apply their own laws, domestic laws, to deal with this international space. Now, let's see that how to adjust this. Now, though the internet is borderless, expectations regarding privacy in different countries around the world is different. This is the issue. Now, this was discussed in Tolley versus Fry case. Now, there what happened was the person, the lady, gave image, picture to one of the magazines in a European country. So they published this magazine. They sent some magazines to Japan, Korea, and those countries. They carried this lady's pictures. Then she filed a case against publishers. That court held that this is nature of electronic publication. That you can't limit electronic publication to a particular jurisdiction. So it is obvious that when you give this picture, that you would have understood this nature and behavior of this electronic publication. So as a result, she failed the case. But earlier, that situation was different. It's the print media. You would have asked, okay, what are the places that you are going to publish this circulation, where the geographical location like that. But here, today, you can't see that. Next. Now, it is the expectation of the customer to preserve his personal information given to the website window. Now, when you open your website, they are asking various questions. They ask about your personal data. To get something through this website, otherwise there is no other place to get this goods or service, what you do is, you also give this, your personal data to website. You feed, you give that. Then what is the guarantee that collector website will not pass your messages to a third party? Sometimes when you open website, even without your knowledge, cookies come to your screen. Not Manchi Hawaii cookies or Melbourne cookies, it's computer cookies. Computer cookies will come to your monitor. The cookies will carry a spy service. Cookies will get your information and pass to their master. Cookie has no brain. His role is to pass message to his master. So then thereafter they will create separate database. So as a result, from next day onward, we will get some messages. Genuinely tell me, if you open your email account, how many email accounts are there, unwanted emails? In the early morning, if you get 25 emails, how many emails are important to you? 5, 6, sometimes 2, or the other emails are unwanted, sometimes about magazine, drugs, and various things. So that means one day at least you would have gone to the particular website. So as a result, cookie has informed that to masters. So then you get this information. You may feel that someone had given my email address to another person. No, that is not the reason. Right. Now, various people ask various questions about they get some unwanted thing. Of course, then I know when they tell, okay, what has happened. At least one day you would have gone for this particular website. So thereafter they start give this information. So anyway, this is also violation. This is also violation. This is also violation of my right. Then when we give these details to website, there must be a guarantee to protect my data, especially personal data, sensitive data. Even cookies, if they take my data, they must give that information to me, saying that they are collecting this data. Secretly, they can't collect this. But anyway, the situation of different, even in Sri Lanka, prior to Act number 9 of 2022. Now, people can't do it. But prior to that act, this was the situation. Still, this is the situation in India, Maldives, and various other countries, especially in Asia. That we should respect the rights of individuals to decide for them whether they want private information communication to others. This is an exception. If you like, you can give consent. With your consent, the data collector can send this data to others. Next. If we receive certain information about unwanted drugs as spam email, it will be a violation of all 3 kinds of privacy. All 3 kinds means this invade of your property, person, or your reputation. There can be violation of all these. A collection of data using internet cookies without informing the user of authorities, and phishing. Phishing means there are some people using various tools. We can't claim damages for mental damage. When we draft plains and answers, what we do is, it is really psychiatric damage or any mental harm goes to that person. But if you put that purely, that we can't get damages or compensation. What we do is explain in that as a result of that. Now this person has lost the employment, his children suffered, the shortage of food and things. When we calculate amount and put that as a physical damage. This is how we get damages or compensation. But some countries, straight away, you can claim damages for psychiatric damages. Now the question arises on social media. On social media, sometimes it is very difficult to interpret as a result of some video clips or some items published on Facebook or other social media, that person got physical harm. It's an accident or something, of course, we can calculate and satisfy the court, but here it is only mental trauma. It's a mental issue. Then how to get compensation? If we didn't have this Data Protection Act, so this is what happened up to last year, there was no remedy. But now, under data protection law, we introduced this data protection law following GDPR in European Union. Now, the person is entitled to get damages following Data Protection Act. Now let's see what is the attitude and what is the situation in some countries. Take what is the attitude of Englishmen? What is the situation of English court? English court reluctant to lay down new rules of common law or equity on privacy policies, since it is the duty of the legislature. What they say is, don't come before courts and ask us to create privacy policies or data protection. It is to the legislature. Go to parliament and look after that matter. So we have three pillars: legislature, executive, and judiciary. Judiciary is not there to introduce laws. Judiciary is there to interpret laws. Lawmakers are the one here. If you want a special law, of course, you must consult them. There's a recent judgment by Dr. Shinani Bandaranaike, delivered in the Supreme Court. She specifically in that judgment also said, courts are there not to create laws. Courts are there to interpret laws. So that means cut and polish. But anyway, that impliedly sometimes there may be new law. But straight away that court can't introduce law. Then English court is reluctant to protect one's privacy policies. What they say they are, it is a superior democratic country. The people must know their responsibility. So this was discussed in various judgments. I have given some references there. Next. Now, what is the situation in France? This is a closer country to UK. But France maintained totally different situation. The France they are very strict. Even celebrities also can protect their personal life. This is the situation there in France. So what happened is it happened that Kate, that princess came from UK, the royal family. They went there holidaying. Some paparazzi people there. They got some photograph of this topless pictures of the Kate, and they published that in some magazines. Then their public litigation mechanism is very, very powerful. They immediately filed action before courts. The court said that it's a clear violation of privacy of this royal couple. Immediately ordered to recall all magazines and destroy and pay compensation to this royal family. Similar application was made before English court. They said, no, people have right to information. This expression. Royal family didn't get anything from their own court, but they got maximum compensation through French court. What's the situation in India? I will not go through each and every judgment. Anyway, when you look at these judgments, what happened was they also maintained some privacy policies. But unlike GDPR, like in UK and EU countries, they also have some laws. These politicians, this happened to some politicians. Some newspaper people, they publish their criminal records and financial records in the newspaper. So then they file action against these newspapers. Court tells that no, you are going to contest. That means you are a public figure. Voters must know what is your financial situation. After seeing their bank accounts, of course, people will decide how they earn. Then one person challenged, saying that you have published my criminal records. They were not convicted people. Convicted, of course, then this will be public report. You can publish. They have published the pending cases. So that's why they challenge. But court tells that you are a public figure. If you are going to contest, your voters must know your behavior, your situation. Then they rejected it. So that is how the courts interfered and safeguard the rights of people and the society. But they consider here society first. What's the situation in Sri Lanka? I will keep big question mark and stop. Yeah. Next slide. Right. Now, what is the data protection laws and privacy policies in various jurisdictions? The Article 17 of the International Covenant on Civil and Political Rights, we also follow the same law. Yes, we also have Act, states no one shall be subjected to arbitrary and unlawful interference with privacy. Now, we also have Article 14A in our Constitution. We are given the same right. So, based on that, now we have introduced our Data Protection Law, Data Protection Act. In the European Union, they have organizations for economic cooperation and development. We call this as OECD. OECD has issued a set of guidelines for the protection of privacy and transborder flows of personal data as a model in 1980. Based on that, they developed later data protection directive. As far as electronic transactions are concerned, they developed that data protection and they introduced another directive. Then thereafter, they felt that it's also not enough. Then they introduced General Data Protection Regulation. We call this as GDPR. This is the situation in the European Union. I have given these numbers that earlier. Right. Next. Now, as I explained to you earlier, EU, of course, this is the directive. All member countries must, it's mandatory, they must follow their directive. Under their data protection directive, they have directed all countries, if they don't have data protection law, to introduce new data protection law. If they have data protection law, to bring that for their standard data protection law according to the directive. Then outside EU, what they did was, I explained to you that Americans especially, they voluntarily accepted this data protection directive earlier, now GDPR, because to carry out their business ties with European Union countries. We call this as safe harbor. Go to next one. Right. This is the latest situation in EU, because why we must discuss this General Data Protection Regulation, because based on this GDPR, our legislature, our parliament also drafted Data Protection Act number 9 of 22. So therefore, we must know the principles behind this GDPR. Then it is easy to read this act. Otherwise, if you read only this act, if you are a lawyer, of course you will understand. Even as a lawyer, sometimes it is very difficult to understand our own act. Since we hired these provisions from EU countries, it is very much easy to understand their principles and then read our act. So after finishing this discussion, today you go home and download our act and read, then you will understand the law available in this country. This is a new EU regulation, comes into force on 25th of May 2018. It replaces Data Protection Directive. But it's not a total new law. Step by step, they replace the provisions under Data Protection Directive. Then regulation in EU law on data protection and privacy for all individual citizens. It's applied to all individual citizens in EU region. And improve privacy and give greater control to customers and citizens over their personal information. That is the main objective. Next. So these are the 7 principles that we will find under GDPR. You see that the fine set of these policies. Let's take first, there must be lawfulness, fairness and transparency. We call the person who is having personal data, say if I have personal data, sensitive data, the law calls me as data subject. I am the data subject. You are also data subject. The collector, we call that collector as data collector. And if they want to process this data, we call the processors as data processors. It's like a triangle. Right? Data processors are there, data collectors are there. We call these data collectors as data controllers and data subject. Now, it is the duty of the data controller or data collector to show that lawfulness, fairness and transparency to collect someone's sensitive data. Now, take example at a job interview. If the employer asks various questions, if the sensitive data or private data of the employee or the future employees, and that it is still that employer interview him, they must explain him why they want to know about this sensitive data. So that is why must be fairness must be there and lawfulness must be there. If a person come to get a job, say if it is a garage, small garage, then you can't find out what is your religion and thing, right? There must be religion with motor vehicles. Then of course you can ask. Otherwise you must tell him, why, what the reason you put that question. There is a lawfulness must be there. And fairness must be there. And the transparency must be there. It's applied to websites as well. When they display something and if they asked the questions and if they try to collect your personal data, sensitive data, they must give reason. They can collect legally only. The lawfulness must be there. The transparency must be there. Why they collect this data? Second principle is purpose limitation. They must limit the collection of sensitive data or a private data for a purpose of processing only. Processing for particular reason only. Then data minimization. If they collected sensitive or private data exceeding their limits, as I explained you earlier, that name of the father is immaterial to the employment, anyway that they have asked that question, now the details are with him, then it is the duty of the data collector to return that data or erase that data or remove that data. They can't keep that. They have no right. We call this the principle as data minimization. Data minimization. For a purpose only they can keep one's sensitive data, private data. Then accuracy. After giving this sensitive data or private data to a data collector, they must maintain our data accurately. If they process, after processing, if they change, if they modify our data, and as a result, it will tarnish our good name, then of course I can ask that data collector to rectify it. So this is called the fourth principle, to maintain, that is the duty of the data collector to maintain accuracy. Then next is storage limitation. Now take example. This year, if my virus guard is Kaspersky. See Kaspersky? Right. Now say Kaspersky, before I install, they will ask various questions. If they are some sensitive data or private data from me, I will give, because there's a license during next 12 months. After 12 months, I will not extend my license. I will go to Norton antivirus. So that is my next virus guard people. So that means I will conclude my license after 12 months. But this Kaspersky people had collected my sensitive or private data. Then it is the duty of the Kaspersky to return my data collected by them at the end of this license period. They can't keep it. They can't keep it. But if there is no law, they will misuse that. Now they are bound to return this data. So thereafter, I will give the same details to Norton antivirus. I just gave you some example, right? Because this is what's happening in cyberspace. We call this policy as a principle as storage limitation. The next, integrity and confidentiality. That means security. When the data collector collect one sensitive data or private data, he must explain the data subject the way they have taken step to protect their sensitive data. They must give the assurance. This is the mechanism we have applied to safeguard, protect your sensitive data. Otherwise, you can't collect. If the data subject is satisfied with that mechanism, they will give. Otherwise, they will not give. For that purpose, they must maintain that. Then finally, accountability must be there. At any time, data subject can inquire about his sensitive data or private data. Or if he is not satisfied, he can ask them to, okay, I want to withdraw my consent. Then it's a mandatory duty of the collector to erase that data, remove that data. So these are the 7 principles. Now this is very important as far as online transactions are concerned. Otherwise, we just give our personal data, sensitive data to website. They also collect that. We also don't think much. Ultimately, we don't know what happened to our data. Next, after this, of course, we'll have a break. Right? Anyway, when you look at GDPR, it's a fundamental right today maintained in European Union countries. Next slide. This is the situation in the United States. As I explained you earlier, there was no separate privacy protection law, but they have various acts guaranteeing their data protection of their citizens. Now take example, Online Privacy Protection Act, we call this OPA, and even for children also there is act, we call this COPA. Likewise, there are a series of acts. When you look at these acts, of course, they have secured sensitive data or private data of American citizens. Anyway, the California, that state, it's different. California has introduced a piece of legislation mainly following GDPR in European Union. Next. Then there was a case, Jutnik versus DoubleClick. It is easy to remember, the Jutnik versus DoubleClick. There, what happened was Jutnik gave some information to DoubleClick Corporation. So what they did was they process and they use this data and they give this information to others. Then Jutnik filed an action saying that this is my personal sensitive data. But court held that data protection mode apply for private and household matters. Now, this is the law in this country as well. This is one exception under our Data Protection Act. You can't apply this protection for private data processing, or for if this data or data processing applied for household matters. This is exception. Next. In Australia also same. They also follow the GDPR at the moment. Next. New Zealand, when you take New Zealand and Hong Kong, these are the two countries at the moment who maintain very successful data protection law. Even it's much stronger than European Union data protection, because they maintain the Privacy Commissioner's system. Recently, Australia also ordered heavy compensation against Google Bus, saying that they collected data from the customers. There was no security, especially for Australian citizens. Not only Australian citizens, same thing happened to us, but no one looked after our sensitive data. And the Australian government came forward and they filed a case against Google and awarded heavy compensation to people and ordered heavy fine against Google Bus. Next. This is the situation in India. As far as Information Technology Act in India are concerned, various provisions are there. Next. The situation in United Kingdom, of course, they changed their earlier attitude following Data Protection Directive in EU. They introduced Act 2018. But after Brexit, now what they say is this GDPR is also not enough. Now this is the situation there in UK. Now they say GDPR is also not enough. So they are trying to draft the new act for UK very soon. We can see the brand new Data Protection Act in UK. Next. Right. With that, of course, I hope that I gave you a general idea about the international situation. Let's see after the break what the situation in Sri Lanka. I will address some provisions under our Act. Do you have any questions? What are the questions you have? No questions means you all are experts. Anyway, government is searching to recruit some people for Data Protection Commission. Still, they couldn't nominate people for the Data Protection Commission. You can apply. Otherwise, please ask questions. Yeah. Yeah. If they come here, of course, they are subject to our law. That is what they say. There is a provision, I will discuss trans-border data. If we send our data to China, then there are some limitations. We have given some provisions to how to control data in that soil. The same thing happened to Chinese also. The China company, they also have trans-border provisions. Even in GDPR also same. Because their main rule is that EU country can't send sensitive data or transport that sensitive data or private data to a third country if that country doesn't maintain privacy policies or data protection up to their standard. Now, this is what happened to Sri Lanka. I will just said just before the break, I forgot to tell you what happened to our T. Mahakata. He asked me, Now, 1867 or 18, I can't remember the exact year, they introduced tea industry to Sri Lanka. Before that, we had Cinchona, right, it's tea industry. Those days, we produced broken orange pekoe. So today, still that we can see proudly, English breakfast tea is available in UK. What is the brand now we manufacture today? Today also same. But their drinking habit may change now. We must understand their drinking habit in European Union countries. To know their drinking habit, we must get information. They don't send this information, they didn't. Now they can send after introducing this act. They didn't send this information to Sri Lanka because we didn't have data protection here. But they didn't send. So then up last year, we also still continuously we produce broken orange pekoe, world best tea, brand only ultimately. We lost tea market. Then garments also we export to European Union, especially take underclothes. Others, of course, you can measure and you can send underclothes, especially that is very important, the material, and they are considering their climate and everything. How to get this information? That is very sensitive data. So they didn't send this information to country like Sri Lanka because we didn't have proper data protection law. But anyway, we shouted and screamed, please, international investors, please come and invest money here. Who are the people come to Sri Lanka when there is no data protection here? What is the guarantee for their money? But at least now we have act. I don't know how far it will take to establish that. So this is the situation. After struggling, after forcing authorities only, this data protection came into operation. What is our data protection act? I will discuss after break. Carbon copy of GDPR. Why? What was the delay? Unanswerable. This is the situation in Chinese and. Do you have the questions? Yes.
Sir, we've got some questions about online.
Okay.
Online portals. So, the use of AI is on the rise. As it evolves, it magnifies the use of personal information in ways that include privacy interests. This includes the facial recognition at airports. So, how protected are we when it comes to the rise of AI?
Right. Okay. When I will answer that. When we are discussing our provisions under our act, it is easy. Otherwise, I have to continue another 10-15 minutes before your break. That answer is there. What are the other questions?
Another question is there. With e-commerce, how to protect data?
This is the law. That's why the data protection came into operation, especially considering online transaction. When you look at this other, that traditional transaction, of course, there was no much issues. But now when you consider this online transaction, there are lots of issues. So that is why this data protection came into operation, considering GDPR. Yeah.
Another question. Although Section 5.3 specifies exemptions of RTI regime in Sri Lanka, Section 5.3 is all about public interest override. There are several orders issued by RTIC with challenges. Dr. Abeyaratne's position on this, while Data Protection Act prioritizes privacy, RTI Act prioritizes public interest, which is very information. It would be great if Dr. Abeyaratne can bring insights, nuances on finding a balance between sensitive data of public authorities and public interest.
Yeah, it's a very subjective matter. So case by case, we have to discuss. This is what I displayed one slide. It's a real battle between privacy, data protection versus right to information. So that you must give the priority, the safety of the society. Society means you and I. All are there. That is, we are talking about individual interest. Anyway, if there's a violation, then we have to give the protection. So we have to balance the situation. This is a balanced process. Yeah, please.
Right to information, you could ask certain information to public authorities. There are people, public officials. From data protection law, are there any impact to the RTA Act? Section 8 of the Act can require information about the decision-making process. Decision-making process involve people. So is there an impact on the potential of that? And second thing is, when they are a private company, you could ask information from the government authority. They are supported by that. The private company is getting certain contract from the government, that private entity becomes public authority under right to information act. So is there an impact to that clause?
First one, of course, under exception, that is one provision. If it's a violation of one's data, that means sensitive data. If it is a violation of one's sensitive data, then Right to Information Act, that one is one of the exemption.
Example, like I say, committee members' names can be published, right? From the
Now, before that, we can get the other example. There's a HIV patient.
Not actually, it's a decision making about public finance and the decision.
Yeah. Then, of course, there can't be any sensitive data. There is no sensitive data involved in that. Then that is our right. If the information, say from through the health authorities, if they are trying to take some authority, that information, if it is effective that one sensitive data, then that is exempt. Other one, okay, you can't directly ask you can't get information about the private institution. But up to the extent that if it is sponsors, that government sponsorship, take examples, maybe some BOI, it can be BOI project even. Up to the extent that their involvement, I think our BOI, the legal office is also here because you can get this answer much better than me. Anyway, up to the extent that we can't enter the territory of that private part. That up to the extent that the involvement of the public body, we are entitled to get. So they are sometimes impliedly, sometimes it may come out. That is why RTI officer is there to decide. Then RTI officer says, no, I can issue. Sometimes if that private company feels that it's our private data going out and sensitive data, financial data going out, they can object. On the other hand, if the applicant feels that, refuses to give that information, the violation of the provisions under this act, then he can apply to the commission. Then commission has to decide. Even if he is not satisfied with that, he can go to courts and find out. This is the mechanism.
Is there any significant change to the RTA?
I did follow that.
Is there any significant impact to the RTA by the data protection?
Yes, of course. Now, of course, our rights have been guaranteed. So earlier, now take that that situation in India. I cited some judgments. Very soon it will happen to our country also. Someone can say this is the financial privacy. That can say my other internet privacy or whatever it is. But this is how courts interpret it. So because we must know our exact rights. So this RTA and data protection is a must to a country, because otherwise you and I, we are not safe in this country. Okay, we'll have a short break and come back. Then I will explain those provisions under Data Protection Act in Sri Lanka. Anyway, if you have any questions, I'm available. You can ask them.
As you said, in the courts, if there is any dispute related to the data protection in the court, you said the judge may interpret the laws only. But there is in current power of the court, there is any laws is not available related to the dispute of this data protection. Can't the court using this inherent power and give the judgment?
Can you repeat that question? Because you got some hum earlier. Can you repeat the question? Even without mic, you can ask.
Now can you? No?
No need to mic. I think it's clear.
Yeah. So, as you said that in the courts, there are very disputes arise related to this very hot matter, especially for this data protection dispute. If there are any law is not there, you said that judge can only interpret the law. But there is the inherent source of can't the judge use this power and if there is any dispute, it is not in the laws that to affect the data protection environment.
No, this is what this is the role of the judiciary to reshape and interpret the law, because they can't create, like Parliament, they can't introduce law. That is what I say. Judiciary is not there to create laws. Impliedly, what happened is we go for the cut and policy situation. Then, of course, some new provisions might come. This is the role of the judiciary is to fill the gaps and find the loopholes and fill them, not to bring a new law. In this journey, sometimes that law, that intention of but they have to consider various things. Hansard report, the intention of the Parliament to bring a particular law. After considering all these matters only, that judges interpret any law. So sometimes after giving the judgment only, we realize sometimes intention, what we discussed at the Parliament was different to final interpretation. Sometimes that judiciary has to go for it, because as far as all the overall provisions are concerned. That it is not the role of the judiciary to introduce new law. It's to the Parliament. That is why legislature is that one of three pillars. That is their role. When it comes to courts, of course, then court has to consider the fundamental rights mainly, the provisions under the Constitution mainly, even other the social the situation here, the customs, and you have to consider everything and interpret particular provision. If the plain language is there, of course, the court will not interfere with that. That is up to the Parliament. But if there's vague provisions are there, sometimes you can't understand, and loopholes are there, then court will go for interpretation. It applies to data protection and privacy policies and right to information as well. Of course, we just started this Data Protection Act. We have to go a long journey. That's what I said. Even to capture T-market with that, of course, it will take another couple of years. This, of course, we have to consider everything is that media, ethics and everything. You have to adjust everything. Not only that, if there is a criminal matter incident taken place, in the evening, you will come to know about the suspect, whether right or wrong, all investigation and everything. No need to have identification period thereafter. Of course, I won a case. That means what happened was the only evidence was identification period. But anyway, the day they telecast, of course, I advise my client to record everything and keep. So then they conducted identification period. After a couple of years, that matter came for trial. Then they started to lead evidence of this identification period. Then that is the objection I raised. What's the point of having identification period? Not only the victims, entire world came to know about it. That is one. Not only that, we had a series of what has happened to Sayas matter. What is the publicity give? Some defense lawyers couldn't go to Gampaha courts. There was a big protest against those lawyers, asking not to appear for them. But anyway, there are a couple of lawyers were there, they went and they appeared. Due to this DNA technology, ultimately they found that that is not the real suspect. Then what does the publication give? the police also must be responsible. That police can't act in a irresponsible way. It's the duty of the officer in charge to collect this material as evidence, not to release to media. Not to release to media. Our country situation is all different. Anyway, in future, people will challenge under this act. They will be in trouble because at the moment, even the police department also, some people they know, but some people they are not aware. Why? There's a big incident in Bandaraville or some the OIC in front of that, the way there he talked to the lady, ultimately got a video clip and published on TV on the same day. He was transferred, and so these are the consequences. Anyway, when you look at these some provisions, of course, you can't. That whistleblowers can collect sensitive data for a criminal interrogations and investigations. It doesn't mean that they can leak this to a third party, to the rest of the. They can collect, they are entitled, but for criminal investigations. The release in this, of course, totally the violation of this provision.
Then I think provisions regarding the recordings of meetings, like normally in a meeting, the minutes cannot tell everything what they discuss at the meeting. We had a bad experience in one of the institutions. And the meetings here, we use abusive words for all the ladies. And we requested the information recording under right to information. Okay. Then the information officer says, after the information of needs, the small verification and all, they destroy the data. The end of the institution also part of it. Okay, the witness, the end of the institution, and they destroy the data. So what can we do for that?
It is not surely, it is not private data, it's a public. For that, of course, there must be some circulars and thing, of course, some directives how to conduct meetings. So that meetings come within that scope. First of all, that we must point out what is the understanding.
Yeah, it means, yes, no, government, we have to establish a law and everything, but it says something what should be maintained, reports. Because soon when everything started recent, so that part is not there. So they said
They want to know.
everything is not included in the regulation. So they just restore. The purpose is safeguard themselves. Because of the abuse others. I mean, it's also part of the
Reason.
the protection is not there. So how we proceed these characters?
You have to go through this, there's a long list of exceptions. Exceptions are there to find out whether it comes under one of these exceptions. But this is not the time to discuss. There are more than a couple of pages in the active. So that is why when you say right to information, that is the preamble. Ultimately, we have lost our right to information. Earlier, we didn't have this issue. That is why media protested. So this is our right to information act. Telling that is right to information act, end result was different. Thank you. Can you what more? Because we have finished these slides. Some, yes. Yeah. Right. We discussed the international, the situation and how these other jurisdictions, they maintain, especially the Data Protection Act, Data Protection Law. Now, what is the situation? When you travel in a public transport, can you get a photograph to a person, all right, with other people also in the background? Young couple is there. Okay, have nothing to do with your photography. You take photograph capturing that young couple. Can you do it? What's the situation? Can you do it? I am asking not morally, that whether can you do it? So already it happened. There was an incident. That girl who wanted to go for that tuition class, they got friendly with another young boy. He was working somewhere. Then they got an intercity railway ticket, and they want to go to Peradini Gardens or somewhere. Right? While they were traveling, the person got a photograph. Then this young couple was also there. One of them, one of the team members, knew this couple, the girl. Immediately, within a couple of seconds, he transferred that picture to her parents. Parents, by road, our trains, but it will take a long time there. By road, when they got down to Peradini station, parents are there. Now, can you do this? But they have already got that picture.
Yes, after that.
All that here at the time of taking that picture.
At
That's
the time.
right. Purpose is to sabotage that love affair. What is the other purpose? What's the business they have? Right. If you travel to public transport, bus or train in China or Japan, if you take photograph, the picture, if the person, especially girls are very, very tough girls are there, right? If they feel that his face or he is inside that picture, definitely he'll come and demand, show me the picture. And if she is there or if he is there, that they can demand, delete that picture from the system. Because it's covered under this data protection. It's your privacy. So anyway, that after now our data protection act is also in operation. But how many people are still continuing this? Still they are taking photograph. This is an operation from last May. This act came into operation in May, Act number 9 of 2022. So this is the message we must give to society. That now after following this course, because this is what the organizers said, to take this nation to correct direction. That is the intention. Right, okay, now we have duty now. After learning, I don't know if it's a learning or listening anyway, I feel that's a learning, in at least listening, now came to know something about this. Please give this message to society. So this is prohibited. Right? This is prohibited. You know, if there's a violation of, I don't have time to discuss in detail. Now I will, since you raised it, I will tell you. Do you know what's the fine? 1 million. 1 million rupees. Under our act. It is so serious. It is so serious. People are not aware.
Ask one question related to these pictures. So currently, like in schools and universities and even in institutions, so they do capture the pictures of students who are under 18 for their marketing purposes without the consent. So is this act do something on that?
Parents can object. Parents can object. Without their consent, they can't. So the purpose of this act is to give the consent, then there is no application of this act. The issue is if the child is under 18 years, can that child give consent? He or she is not major. So then the person must be there as a guardian, parents or guardian, that he or she must give that consent.
So I read another case on Norway and on even the kids, once they have grown up, in 18 plus. I heard a case that they have sued against the parents where they have posted an inappropriate picture of that particular person in the age of 3 or 4 in social media. So in our act, will it be like that in future?
Definitely. Whole issue is still that even our legal community also, they couldn't understand this act. I don't know whether they have read even. We have to, we also planning to conduct various workshops. It will take a couple of years to settle down this first. First, they must know this act. Then only they can advise people. Then the more and more litigants come. Then they will take this case before court. So at the moment, I also have to discuss this act according to the four corners of this act. Only lines, black and white, black letters are there in the white sheet. This is what I am discussing. Anyway, now we have a background. Taking examples from European Union, that privacy policies are there. When you look at this act, we also have drafted based on these policies. Now it is very easy to interpret. So that is why when you ask that question, I answered yes, because we can predict. This is what happened in EU countries. Definitely the matter comes before courts. Courts will go through the case law, especially in UK, because that is the requirement under Section 100 of Evidence Ordinance. If there is no provision in this materials in this country, we have to follow English law. Then automatically we can hire judgments from UK. Still, we are under British colonial system. Don't worry. We have the provision. At least that provision is there. Even after getting independence, still that provision is there. If there is no law available in Sri Lanka, then we have to follow English law. So then, if there is judgment in UK, we can take that. So that is one advantage. One way that is good. So that is why we can predict. Otherwise, if you ask questions of I also can't answer until we get some judgment from courts. So anyway, when you look at the structure of this Data Protection Act in Sri Lanka, we have hired same principles, 7 principles under GDPR. Okay. Let's go. I will briefly explain this, spending a couple of minutes. As far as the Section 10 of Computer Crime Act, now before this Data Protection Act, we honored data collected from various people during the course of investigation relevant to computer crime. Part 2 of Computer Crime Act explains what is the protection, including data, collected by authorities, investigators, and how to protect that. And because it is a duty of the investigator to give a list of all data collected by them to the person, that means data subject. It's a mandatory rule. Now, that is there. Now, when you look at the Part 2 of Computer Crime Act, that's a good security. Other than that, there was no other provisions. Now, after bringing this act, now we can apply data protection as well as Part 2 of Computer Crime Act. If these authorities, even these investigators, if they leak, now you can get the answer. How these police, when they leaked to general public, couple this Part 2 of Computer Crime Act and Data Protection Act and do the justice. I can't give verdict anyway. That is up to you. How to blend these laws. I can only give hints. I can direct you. Right. Section 19 of Computer Crime Act, number 24 of 2007, has empowered the investigators under the Act to give directions to responsible people to preserve such data for a period specified in the same order. So even during investigation, investigators can ask some. There's a special provision is also there under Part 2, because the legislature also knew competence of police department. Since there are no much competent officers attached to police department, that is obviously their role of investigation is different. We can't expect everything from the Sri Lanka police. So they can get the assistance of graduate who is in the position of Bachelor of Science in IT, BIT. Then the Vice Chancellor will certify these graduates with the permission of Minister in charge of the subject. They will nominate them as experts to carry investigations like police officers under Part 2 of Computer Crime Act. It's applied to them as well. So they can give various directions to any citizen, even if they come to my house and ask me to, don't open C drive, don't open D drive, or don't touch the computer. Though they are not in uniform, can't help, we have to honor their directive, because they are carrying official duty. They are acting as peace officers. They have they can arrest us if they violate. This is the powers given them. This applies to them also, because if they, after collecting some data during their course of investigations, they have to maintain secrecy. They can't give this information to third party. They can't give to media. They can't give this item to the media. Anyway, that is under Computer Crime Act. Computer Crime Act. Anyway, now we have Data Protection Act. Next one. Right. This is the personal data. These are the objectives of this act. To introduce regulation of processing of personal data. That is one objective. To introduce regulation of processing of personal data. Now, when you look at this first objective, it is very obvious. This act for electronic communication, online transactions. To identify and strengthen the rights of data subjects. We are data subjects. We have our sensitive data. Providing for a designation of the Data Protection Authority. Under this act, the minister has to nominate, through president has to finally approved for this authority. Up to date, there is no authority appointed. And to regulate the dissemination of unsolicited message using personal data, and further to provide for matters connected to the same. So these are the main objectives. This law has been introduced to facilitate the growth and innovation in the digital economy of the country. Now we are highly talking about a digital economy these days, right? So this is the act now. Whilst protecting individuals' rights and ensuring the consumer trust in information privacy in online transactions and information network. Now this is the preamble. If it is so, it's applied to all websites, all online transactions. Now remember, that is our right now. When they ask various questions, go back to the 7 principles, because all 7 principles are there under this act. Next. We'll pass them. Right. What is section 2 says? The application of the act. Applied to the processing of personal data. Processing takes place wholly or partly within Sri Lanka. If the processing is totally outside Sri Lanka, we can't apply this act. Totally or part of processing must be in Sri Lanka. Processing of personal data is carried out by a controller or processor who is domiciled or ordinary resident in Sri Lanka, is incorporated or established under any written law of Sri Lanka, offers goods or services to data subjects in Sri Lanka, specifically monitors the behavior of data subjects in Sri Lanka. I think you asked a question, your answer is there now. It's applied to Chinese people, they are here. So they are coming under this category, one of this category. Anyway, these are the exceptions. Any personal data processed purely for personal, domestic or household purposes by an individual, not by any corporation, company or anything. And any data other than personal data. Now what is that? Now, if I ask you to give your name and addresses who participate for this discussion, I can pass a sheet of paper. You will also write your name and address and give me. Now, I will keep as a database. Is it coming under this act? Is it coming under this act? No. It is for my personal. I want to keep my personal contacts with you. Right? So it won't come under this act. It's purely for personal. Then for domestic or household purposes. Can you remember what happened in Jutnik versus Double Click case? Like the Jutnik case, it is very clearly that court held that it won't apply data protection law, it won't apply for household purposes. So these are the exceptions. Then you can't apply this for public data. It's applied only for personal data. Under these exceptions only, you have to interpret provisions under this act. Is it clear? So otherwise you may feel that we can do everything through this act. So these are limitations. Next. So you can find 5 schedules under this act, because we can't find these schedules under GDPR anyway, that our act has 5 schedules. First schedule explains conditions for lawful processing. Now take example, schedule 1, first item is you must get consent of data subject. If the data subject gives the consent, then controller will get that consent, then that control is not subject to, he will not subject to this act. So likewise, the second schedule explains the processing of special categories of data. Special categories of data there. Please download this and read this, then you will realize what this special category means. The data subject has given consent to the processing of special categories of personal data for one or more purposes specified by the controller at the time of processing, unless any other written law prohibits the processing of such personal data, notwithstanding the consent of the data subject concerned. In the case of a child, consent shall mean the consent of the parent or legal guardian. Now the answer is there. Processing is necessary for the purposes of carrying out the obligations of the controller and exercising of the rights of the data subject in the fields of employment, social security, including pension, and for public health purpose, ensuring public safety. Likewise, they have given this list. So it comes under second category. Now there is a specific way to get consent from the guardian, head of the department, workplace, like that. Third schedule explains conditions for consent of the data subject. Now how to get this, the way to get the consent. Where the personal data relating to a data subject, the controller shall demonstrate that the data subject has consented to processing of the personal data relating to such data subject. Then there again, they have listed these items. Then come to Schedule 4, processing of personal data relating to criminal investigations. Processing of personal data relating to lawful investigations of officers or related security measures shall be carried out only in accordance with applicable written laws, whilst providing for appropriate safeguards for the rights and freedoms of data subjects. This is for whistleblowers, police, bribery, and these officers. For the avoidance of doubt, processing of personal data may be considered lawful under this schedule if investigations are carried out pursuant to the provisions of the Code of Criminal Procedure Code Act. Conditions for providing appropriate safeguards for the rights and freedom of data subjects under this schedule may be as prescribed. So this is for criminal investigation purpose. Then Part 6, Part 5 explains collection of personal data, and 6 of course term of office, up to date because there are some schedules which are not yet operated. When the minister gazette only we can apply these schedules, right? Then Part 1 of the Act explains the obligations of the personal data processing by data controller. Then come to Section 6. Section 6 explains right, obligations to define a purpose for personal data processing. Now look at the first principle under GDPR, that is there. This is what this Section 6 explains. Section 7 explains obligation to confine personal data processing to the defined purpose. It is the duty of the controller to ensure processing of personal data with limitations to the extent to the purpose for which such data collected or processed. This is what Section 7 explains. Now can you remember purpose, limitation, and these are the principles we learned under GDPR. Like as Section 8 explains obligation to ensure accuracy. Accuracy is also one of the principles we discussed earlier. So Section 9 explains obligation to limit the period of retention personal data. So there also, can you remember, I gave you example of Kaspersky and antivirus matter. So then these limitations are there. Next one. So likewise, please go through these sections and you will come to know, it's explained all principles we discussed under GDPR. All subject to written law of Sri Lanka offers goods or services to data subjects in Sri Lanka and monitors the behavior of data subjects in Sri Lanka. That is the primary objective. Accordingly, this law is applied not only to the processing of personal data only within Sri Lanka, and it applies to foreign data controllers or processors who have interest in data subjects in Sri Lanka. Now let's see, this was important provision. Section 26, we call this as cross-border data flow. Section 26, where a public authority process personal data as a controller or processor, such personal data shall be processed only in Sri Lanka and shall not be processed in a third country, unless the authority in consultation with the controller or processor, as the case may be, and the relevant regulatory or statutory body classifies the categories of personal data which may be permitted to be processed in a third country, prescribed by the minister pursuant to an adequacy decision made under subsection 2. What is 2 says? For the purpose of making an adequacy decision, the minister shall, in consultation with the authority, take into consideration the relevant written law and enforcement mechanisms relating to the protection of personal data in a third country, and the application of the provisions of Part 1, Part 2, and Section 20, 21, 22, 23, 24, 25 of the Part 3 of this Act, and such other prescribed criteria relating to the processing of personal data in a third country for the purpose of cross-border data flow. When you look at the regulations under GDPR, it's the same. Thus, finally, that minister, after introducing certain criteria, test, of course, the authority must declare it is a fit country because that country maintains the proper standard data protection provision laws there. So therefore, the person who wants to send this sensitive data, private data to that country is entitled to send it. This is what happening in European countries as well. Then according to this law is applied not only to the processing of personal data only within Sri Lanka. Earlier that said within Sri Lanka, now it's extended to other countries. The limitation of this act is applied for personal data processed purely for personal, remember, personal, domestic or household purposes by an individual and irreversible anonymized data that causes the individual to be unidentifiable. Right? Next. The consent requirement is also explained under this act. It's like GDPR. So these are the rights of data subject. Right of access to personal data. Can you remember that we discussed accessibility and accountability under GDPR? It is there under Section 13. Section 14 explains right of withdrawal of the consent and the right to object to processing. That means data subject is entitled to demand the data collector to erase his data. Right to rectification or completion, right to erasure, grant or refusal of rectification, completion, erasure or refrain from further processing, automated individual decision making, right of appeal of the data subject to the authority and process of determination of such appeal. Right, next, please go through these sections. I don't need to repeat the same section, it is there, right? And remember, further processing, this is important, I want to tell you. Processor, that means a controller will ask processor to proceed with the process, but controller must satisfy that the processor is fit processor to process particular data, considering their knowledge on technology and required knowledge on law. Likewise, that is how controller decide. If the processor fail to comply with the directives given by the controller, then that liability will come to the processor. Because the processor will be controller, because processor didn't listen to the controller. Otherwise, controller is the person who is the liable person. Controller is liable for if there is a fault as far as processing is concerned. Why? The controller decided, the processor, after going through the qualifications and everything, you are satisfied, so that is why ultimately controller is liable. There are some instances for the public security, that means security of the society, and for scientific purpose, for archaeological purpose, and for archival purpose. If a processor further process, our act says it is not illegal. It is legal. That means data subject has given consent to the particular process. Exceeding that process, the processor further process the data, sensitive data of data subject for those purposes. For the safety of the society, for scientific purpose, archaeological purpose, and archival purpose. Then processor is entitled to do it. Is it clear? Right? This is also exception. If the processor, through the controller, if the processor says, look, as an operation of the law, as a direction given by the authorities, ministry and other regulations, we followed that and we processed further. This is what happened to us. We couldn't limit the possession because this is operation of law. So it is not a violation of Data Protection Act. But that process is entitled to go for further process. Next. So these are the provisions relevant to controllers and processors. So I have explained you that main section. Then section 26 is the most important section here, cross-border data flow. Do you have any questions over that? Cross-border data flow? Of course, you asked that question. Right. The part 4 of this act explains the use of personal data to disseminate solicited message. These also separate provisions are there. Subject to section 14, a controller may use postal services, telecommunication services, electronic means, or any other similar means for the purposes of disseminating messages only if a data message has given consent to receive such messages, hereinafter referred to as solicited messages. Now, how many unsolicited messages are receiving by us? I, of course, normally get 45 to 48 messages per day in the early morning. Then when I go through, they get annoyed also because to find out what are the important messages, not more than 5 messages. Or the other messages are nonsense. So they didn't get my consent. It's a violation of this act. Right. Next. Then part 5 explains Data Protection Authority. It's of a nomination of the Data Protection Authority. Director General is there. This authority has all powers. Right, all powers. If there's any violation, of course, they can report to Colombo Magistrate Court. If any person is not satisfied with that order within 21 days, he can appeal to the Court of Appeal, not to the High Court or any other court, straight to the Court of Appeal. Now you can see the importance of this Provisions Act. If there's a violation, as I explained to you earlier, 1 million, up to 1 million, Data Authority can impose the fine. Anyway, if a person is not satisfied with that fine, if he is not paying, then of course they will file a case before Colombo Magistrate Court. Then still, if they want to appeal against that decision, they can't straight away, they can't go to Court of Appeal without depositing that money. Like appeals from Labour Tribunal to higher forum, they must deposit. If they take example, if the authority impose say 900,000 rupees as a fine, before they appeal, they must deposit that 900,000 rupees. Otherwise, they can't appeal. So that means this is the expectation of the legislature to apply these provisions strictly. So then part 9 of explains miscellaneous provisions, and part 10 provides interpretation for words. That's biometric data and what is likewise, all the interpretations are there. This is, I want to give you the overview of this act. Once again, keep in mind, main principles, when you look at these sections, we have laid down, we have explained all these principles. These are the 7 principles we learned, we discussed earlier under GDPR. Right? Now, what is the application of this act? Of course, we have to follow the procedure and how they achieved by this data of the protection authorities in other countries, especially in UK. to reach their target. That is the only mechanism at the moment, since we don't have case law to give any opinion. Anyway, this is a very serious act. I hope that you will realize it is a very serious act, especially that your organization are dealing with young professionals. When we are working with young people, of course, it is our duty to give the assistance and give that our knowledge, share knowledge with them, this their future. Then with that knowledge, they can go ahead. They can get the mileage because they are knowledgeable. So then they can face for anything. But if you know these provisions, of course, then you are confident. You know this is the law in this country. So there is no other law. Now this for interpretation. This you can interpret. You can interpret. Now how many things have we came to know? How far we know? What's our level of the knowledge? Right? So anyway, remember, there are no experts in this field. I am also like you. I am also carrying various research here, right? I am also part of this society. We are also learning. We are also learning. Now today I explain something. After a couple of years, sometimes court will give different judgment. We don't know. They may go against the situation in UK. We don't know. Considering the situation. At the moment, this is the situation. That is what I can share. I hope that you got something. Anyway, this is only tip of the iceberg. We have to go a long way. With this, we have to learn electronic commerce. That's a completely separate subject. And what is the application of e-commerce? What is the provisions and e-Transactions Act in Sri Lanka? With that, computer crime also involved in that. What are the provisions and the Computer Crime Act? Then how to separate computer provisions and the Computer Crime Act from this Data Protection Act? Then what are the intellectual property rights violation in cyberspace? Then finally will come how to accept electronic evidence before court. So these are the matter we must have some idea about other areas as well. I hope that in one future day, if you organize some workshops, I will meet you. If I get the chance, of course, we will discuss those areas. Since this is very important, this is a piece of legislation very close to individual citizens. That is why we want to discuss. I had a long discussion with Namini and her team, and we realized that they also realized the importance of that. I hope that I have done my duty. If there are any questions, please ask. But there's one question remained. What is that question? Because I didn't hear properly. This is echo. AI matter? AI question. Yes.
The use of AI is on the rise. As it evolves, it magnifies the use of personal information in ways that include privacy interests. This includes the facial recognition at airports. So how protected are we when it comes to the rise of AI?
One area is at the immigration. Of course, this is their state security. The security is an exception. So they can say, we want to get your personal data for their safety, their security. Why is this into? We don't know. The enemy coming to their country, then they must have the controlling mechanism. We have to deal this matter in a different way. Now, under artificial intelligence, of course, we are in danger. Now, robot has come to the level of human brain now. Now, when we were small, that we watched only cartoons. The cartoons, of course, we saw various, because it's always that it is only imagination, it won't happen. Now, when we were reading Arthur C. Clarke's Odyssey, of course, it is like a fairy tale those days. Now, it's a reality. When we watch Knight Rider film, so we never thought that this would happen. Now it is a reality. It's reality. It is much easier to keep Robo as my security officer without recruiting 10-15 security person. It has come to that level. Now there's a serious issue arising here. Now Robo is also learning, looking at ourselves, our body movement, body expression through their cameras, learning in the sense their computer software, the processing. As a result, Even the original software, that writer, computer engineer, sometimes he also doesn't know what happened to his software, because not the single software writer can't write the entire software of the robot. There may be sometimes 500 or maybe 5,000 software writers involved in that to write software. Now take example, I keep this robot with me as my security guard. After some time, now the robot knows my body movement. Right? When I'm happy, robot knows, yes, I'm happy. Robot also will offer a cup of tea. Right? When I'm angry, also robot can understand. After some time, now they are used to that. A simple example is Siri. Siri, if you use Apple iPad or iPhone, we can talk to Siri and get all information. Likewise, now that's also part of artificial intelligence. Now robot will come to know everything. He will get all sensitive data, private data, everything. If robot violates something, if robot transfer this information to another robot, if the robot start love affair with another robot, we don't know in future, after processing, we don't know. Then who is getting the liability? Not only that, dangerous thing. If an enemy comes to my cubicle, if I am the chairman of a company, I keep robot as my security officer. Now robot can understand my body movement. He is coming with a knife. Definitely that person will stab me. It's about to kill me. I don't have any weapon. Now robot can understand my body movement, expression. Then that robot will react. Robot will go and kill that person. Who killed that person? Whose liability? Who is the suspect for that murder? Robot? Okay, we'll ask police constables, handcuff and take this robot. What is my liability? Because to commit any crime, to satisfy any crime, there must be actus rea. We call this as mental element also. Intention, knowledge must be there. When there is no intention, no knowledge, this is not a crime. But here, I didn't have any crime. I didn't give any command. If I gave a command, then I had required intention or knowledge. Here, I didn't do anything. Robot did that. Can we keep quiet? Can we allow these robots to behave like this? No legal provision at the moment. No legal provision. Even the penal code or any other provision, we can't find. There are no section. It is not a murder. But this is a serious threat to the international legal community. Now, international jurists going through this, of course, finally they found only one mechanism. Some provisions are there under very old tort of negligence. It's a tort of negligence. Under tort of negligence says, tort means it's an offense of negligence. If I can't control the robot, it is my duty to destroy it. If I want to keep it, that particular machine or animal must be under my control. Can you keep tiger or lion at the moment like a pet inside your house? Up to that Ahongal incident, of course, yes. We were allowed. Now you can't. Why? If a lion jumped to a person, of course, we are not strong enough to control that animal. If we can't control, even it applies to dogs even. So either we must put that animal into a cage, or otherwise we must hand over that animal to zoo. So likewise, you have to apply same theory here to robots. But the serious issue is, once again, under artificial intelligence, they can get all sensitive data into their hand. Now, how do we know after addressing a Siri, what is the guarantee that Siri will not pass this information to others? Siri won't ask, yes, this transparency is there, now accountability is there, like they address you, no? We just call them, Siri give websites. This is for Siri does. Siri give answers. But we don't know after giving this information, what's happening to our information. So these are the matters that we have to look into that. Before we entering into AI, first of all, we must have at least basic knowledge on this data protection and right to information. So then only we can deal with the high-tech issues. At the moment, we are at very primitive stage. Right. If you don't have any questions, we can wind up. Otherwise,
Sir, we have a question on online portal. Can we hold a camera and move around in public? Can we hold a camera and move around in public?
You can get one thing definitely that consequences of course they are, we can see now, right? Ultimately we lose camera also, that is the situation. Anyway, because they are right. You can't capture others. You can get the scenes and see beaches, or whatever it is. But when you deal with human, now we are subject to this piece of legislation. But what's the purpose to get others' pictures? Why do you want to capture others' pictures in our pictures? To keep as souvenirs? Why? What's the idea? There must be purpose. Why? To show that I was associated with that crowd. If that is the case, of course, you can bring another picture and you can bud and you can introduce. You can but otherwise, what is the reason? No, you can't do it. If someone raises objection, he has to comply with it. Otherwise, he can report to authority. Anyway, we have to go a long way. What else they are?
The legal review instances where a person gets video recorded of movement of a woman at her private premises, and that is without her consent, and he threats he may publish in social media.
Taking something to private, of course, comes under that category. If it is a private household or that purpose, the moment you release that to social media means you have publicized that. This is public now. You can't do it without getting consent of the data subject. So, all right, I don't know whether they got the answer they want, otherwise they can ask again. I don't know, that is what I realized.
Sir, is there any possibility of bringing a charge against a person who has disseminated private content of an individual in so many social media platforms against the consent of that person, and also like instances where multiple fake accounts are created under a particular person's name? Like, can we bring charges maybe under Computer Rights Act?
Yeah.
Is there any possibility?
There are three ways. Now, one is under Data Protection Act. Second, impersonation also. Impersonation is, at the moment, it is an offence under the Penal Code. Or otherwise, we can say, if there is any matter, the way they did that, maybe they are hacking into that, of course, that you have to investigate and see. If it is so, then sometimes you may be in a position to draft charges under Computer Crime Act as well. You can deal with the three ways. In addition to that, if there is any intimidation, if there is a threat carried, again, criminal intimidation is also an offence under our Penal Code.
So most of the time, these instances of online harassment are of such a nature whereby, like especially women or girls, they send their private images in a very private capacity to a person that they trust. And that is totally consensual because it happens with the consent of that person. But just because there is consent in that particular instance does not mean that the person wants it shared in all the public spaces, in social media. But that is what actually happens and it's considered as revenge porn, right? So I was wondering whether there is any controlling mechanism in terms of law to prevent such instances.
So, moment you exceeded that to release that to the social media, from that point onwards, that criminal liability will come to that person. Now, what happened was earlier we had criminal defamation, penal code provision under our penal code. In 2002, after Sunday Times matters, then government removed this offence from our penal code. Now, at the moment, criminal damages is not a criminal offence in Sri Lanka. Actually, that we did that to satisfy media people after the Sunday Times case. this is a mistake that done by then legislature. Normally, other countries, what they did was to safeguard media people, they brought proviso, some exception to media people. Then main offence is there, some exemptions are there. What he did was be removed. So thereafter, that with a lethargic manner, we were silent. Those days, in 2002, the period, the Facebook and social media was not much popular. We didn't have that threat. Then we kept quiet, we silent. Now, we know some criminal provision, penal code provision, but governments are not in a position to bring that. There will be a revolution now if we bring that section back. So this is high time to bring some provisions while safeguarding media people to safeguard this innocent victim. There must be some mechanism considering this rate of these offences. This is for future anyway that we have to think about that. Anyway, that releasing these items to Facebook, of course, this law is very clear. Some audiences, some people ask why the legislature failed to bring offences such as Facebook offences. No, there is no offences called Facebook offences. Facebook and social media is only a platform. It's a platform. Now, through the platform, you carry various activity, good behavior, misconduct, and various. Issue is this. Even I can remember my son history when he was doing O-level. Of course, I saw that he is using some fake that account, that tracking, and of course he was trying to go to this youngster, trying to eBay. Then I told him, don't do it, this is an offense. The very next question he asked, how many convictions there are under this? You have a law in this country? So then how to answer? If they say there is a law, so tell me that what are the judgments? So no judgment. This is the attitude of our people. Not only young people, even that older citizens also, this is the situation. People, they are under impression that there is no law at the moment to deal with offences and criminal activities, misuse activities in cyberspace. But this is wrong. Sri Lanka has all the required legal framework, starting from 1995. We have Act number 14 of 1995, Evidence Special Provisions Act, for admissibility of electronic evidence. Then we have IT Act. So then in 2006, we introduced Electronic Transactions Act. In 2007, we introduced Computer Crime Act. Then we have provisions brought through our Intellectual Property Act in 2003. Now we have Data Protection, a brand new act, number 9 of 2022. We have all required acts. Not only the surprise thing is, this is one of the two countries in Asia had ratified 2 conventions in the world. There are only 2 conventions relevant to electronic transactions. We call this as United Nations International Electronic Contracts. We and Singapore, we have ratified. And the Budapest Convention also, Singapore and Sri Lanka have ratified. You see, what a nation. We are pioneers in IT field. We are pioneers. Because this is one or two countries in Asia who have ratified both conventions. Now, practically, don't ask me. When you go for international forum, sometimes the audience asks, people ask, all right, you are a wonderful country, you have ratified both conventions, you have all this. I gave the list now, I read the list, all acts are there. Now, what is the recent development? What are the latest judgments? We say no judgments. Why? Our people are very, very innocent. We never misuse mobile phone, no computers. Why? If there is misuse, of course, there must be cases. When there are cases, of course, then we go to higher forum and we get judgments, reported judgments. Since the reported judgments are not there, what is the answer we can give? So that means we have required laws. Our law enforcement mechanism is very, very poor. We can't expect everything from law enforcement bodies. We also have a duty. If we know these legal provisions, as a good citizen, we have to honor this law. We also must have that self-control. And we also must be in a position to give this message to us. One day, that police department, bribery company, they will also be competent. Now, we conduct various workshops for them to educate them voluntarily. Because without educating them, we can't think about law enforcement. It will come one day, but at the moment, all must get together and maintain at least this as policy. Right? Yes, now you can go ahead. Yeah. Yeah.
Here we use the personal data protection. That means company data is also included.
Not private.
Only private.
Not private.
Personal data.
If it is personal data for when domestic, it apply for domestic purpose and household matters, exempted. Other than that, of course, all comes under this. But anyway, other exemptions are there. I read you, right? Can you display last slide? For their information, if there's anything, I know that you have no enough time to ask this question and get information. Last slide. Right. These my details are there. If you want, please send me email. Otherwise, send me a SMS. I will try my best to help you and answer. No charges involved.